I don't know who needs to hear this, but lectures are not dictation exercises. You do not have to write every single thing that your lecturer says. Hello and welcome back to SOLegal. If you're new here, hi, I'm Stephanie and you're at the right place if you're looking to make sense of studying law and excel while at it. If you've ever sat down to revise and you realize that your notes are very bulky, but they don't help you understand the concept or the topic, or they don't even help you answer past questions or model questions, then you may be note taking wrongly, and this video is for you. Law note taking isn't just about recording everything you read or you hear. It's more about preparing to think in examination conditions and ensuring that you understand the pith of the concept. So let's talk about how to do that properly in this video. First, why do most law notes just not work? A lot of students take notes as if they're trying to preserve information. They write down everything from lectures, textbooks, and case reports. That's the reason why during my time as a law undergraduate and even now as a law tutor, I hear a lot of students complain that being note-taking readers, they never have enough time to cover their course topics. And even when they have the notes, it doesn't help them prepare well for exams. Well, yes, that's bound to happen because you write everything. Whereas in actual law exams, you're not tested on how much you can write or how much you've written down. You're being tested on whether you can identify issues, state the law, and apply them correctly. So if your notes don't help you do that quickly, then you're doing it wrongly. They're not serving you. Simply, here's the real purpose of law notes. Good law notes should help you recall the rule without searching for too long. Should help you see how the court applied the principles and its exceptions. It should also help you avoid common mistakes, and it should help you structure your answers with confidence. In fact, when you open your notes, you should be able to know exactly where to look at and what to use from those notes. And this is exactly why students who take efficient notes are able to better visualize the information on their notes in the exam hall or whenever they need it. They can just, oh, this is where I wrote it on my note, and this is what I wrote. That's because they took their notes properly. So here's what every good law note should contain. At the very minimum, your notes should have the rule. You should ask yourself, what is the rule? Just state it simply, not in extreme legal jargon, just in an easy way that you can understand it. Second, your notes should answer the question of when that rule applies. This would include conditions or essentials, elements or requirements for the application of that rule. The third question that your notes should answer is which cases show how it works. So this is where you list your judicial authorities, and if there are any applicable statutory authorities as well, you'd mention it. Just list them out very briefly for your cases to summarize them. Not a long story, just a brief summary that shows you the principle and what the courts decided in the cases. The fourth question your law notes should answer to be efficient is what are the gray areas or exceptions? Where do students usually go wrong? What are the areas that examiners usually ask questions on? And what are you supposed to look out for if you see a question like that in your exams? Just brief notes that would guide you for actual exam preparation. That's what you should also include in your notes. And if your notes don't cover these 4 areas, then they need work. You need to adjust. So let's talk about how to actually take notes from lectures, from textbooks, and cases or case reports. Let's begin with lectures. I don't know who needs to hear this, but lectures are not dictation exercises. You do not have to write every single thing that your lecturer says. Rather, listen for repeated points. What's the lecturer saying repeatedly? What is he or she emphasizing? What examples are they using to bring out the points? And are they giving any corrections? Watch out for things like, if you see this question in the exam, do not write this or do not say this. Those are important things that you should take note of in your lecture notes. So again, your job is not to write everything down. It is simply to understand the concepts and take note of major points that help you understand the law and remember how to apply the law. And after the lectures, always spend time to reorganize what you wrote, go through what you've written before. You can add more points from textbooks and your personal study. It makes your notes more efficient because raw notes just don't do the work alone. Now let's talk about taking notes from textbooks. Here's the thing. Textbooks explain, whereas notes simplify. So when you're reading your textbooks, don't copy paragraphs. Rather, read a section and then stop to ask yourself, what exactly is the author saying here? What are the points? What's the principle or application that I need to take note of? That's what you write down, not everything that you see in the chapter. If after reading you cannot explain it simply to put it down in notes, then you have to go back and reread. You should reread it until you're able to explain it in simple terms and then put it down in either short sentences or bullet points. And here's a challenge that's peculiar to law. Many law authors reference cases and analyze them, sometimes adding their own opinions. Then they compare them with other cases. And you find that just on one point, you can have pages upon pages comparing case against case just to show which case the author seems to agree with. When you see things like that, and a good example is Sagay's law of contracts, which is a very good authority on contract law in Nigeria, by the way. But it goes to show how law authors can become how they can give their different opinions on cases, and it could span into pages of textbooks. If you see something like that, do not get embroiled in it. Do not get caught on trying to figure out what should I pick? Should I say this case and then this case and then compare it and then say, oh, this is what Sagay concluded? No, don't. Just read it, get the main principle, and see how courts interpret it differently. And so what you're picking would be the principle, the application, and how maybe a few other cases that would have applied it differently. And this is helpful when you need to distinguish a case in the exams. You may need to have a few examples of how courts have applied a principle differently. In any case, do not get caught up in the long pages of arguments. Pick the main principle and the cases that expound on that principle, and you're good to go. Now let's talk about how to take notes from cases. Case notes can be very bulky. You can read a case from the law reports and it may span into hundreds of pages, especially old English cases or English cases in general. They can be really lengthy. So you do not have to write the full case history. For each case, you should focus on the issue or issues, a brief summary of the facts. Brief summary, so it has to be brief and only contain facts that are relevant to the issues that you're working on. And then it should contain the decision of the court. What did the court decide on those issues? And lastly, you should also note down the principle that was expounded in that case. And those 4 things are all you really need when you're reducing long case reports to brief case notes for revision in the exams. Now, what if you already have long notes over the semester, you already wrote bulky notes, or even did that during the holidays before lectures began and you need to rewrite them? Under what circumstances would you need to rewrite? Well, you may need to rewrite your notes if they are very long, too long to revise from, or if you keep forgetting where things are in your notes. You may also need to rewrite your notes if you understand the topic better now than when you first wrote them. So now you can move from a much bulkier notes to simpler bullet points that you can revise with. You do not have to revise your notes every week. That's just time consuming, exhausting, and unnecessary. But if you do have a need to rewrite them, then do rewrite them. Make them briefer and more efficient. So here's a simple notes structure that you can use when taking notes. For each topic, start with the heading, then a short statement of the rule or principle that's applicable. Then go ahead to talk about the conditions or elements of that principle. Then, naturally, exceptions should follow where applicable. This should be followed by key cases, then common traps or gray areas that are surrounding the rule. For instance, you may want to, at this point, you may want to take notes like, do not confuse this with this. Or you may want to write something like, lashes is different from acquiescence. Lastly, you could add a simple example or application. What this does is that when you're revising or when you're answering past questions, it helps you to know examples in which the principle or rule would apply. So in conclusion, good notes may not automatically make you a good law student, but bad notes make law much harder than it needs to be. So aim for notes that support smart and effective studying, notes that are simple and actually help you, not notes that are bulky, time-consuming, and honestly useless. If this helps, feel free to subscribe and turn on your notifications so that you don't miss a video when we put one up. And we'll see you in our next one. Thank you.